Thank you. Looks like everyone's ready. We are here now for Beecher versus Iowa Department of Revenue, Alcoholic Beverages Divisions. Mr. Appel, you may begin.
Thank you, Chief Justice Christensen, members of the court, Mr. Lundquist. 2 seconds. According to the ABD, that's all it takes to revoke a liquor license for an employee's bad acts of alcohol sales to a minor without any intent of finding by the licensee to do so and no notice of prior wrongdoing to fix those illegal actions. My client, my co-counsel, and I believe that interpretation is inconsistent with the graduating, escalating civil penalty system that embraces recidivist principles under Iowa Code Section 123.50 sub 3, is inconsistent with how to calculate the date of violation based on the plain text under 3E1, and creates consequences and unintended burdens for licensees that even the ABD questions its fairness of. For these reasons and others that we're going to discuss here today, we ask that this court reverse and remand for dismissal of the sanctions associated with the second violation. Our first main argument is to figure out whether the civil penalty statute under subsection 50 sub 3 is a recidivist statute. Of course, in this matter, seeing that the violations were committed on October 15th, 2022, there was no opportunity for the penalty to be imposed before the licensee could learn or fix separate violations coming down the line.
A factual question there. So it looks like the first underage sale was at 9:45 and the second was at 9:50, so there's 5 minutes. Is that, do I have that right?
The officer placed down, I believe during the testimony from Brandon Trapp, who is the ABD's investigator and the witness, it seemed much closer than simply 5 minutes. It seemed like they went up back to back from each other. There was a transaction exchanged, money was exchanged. It doesn't seem like it's 5 minutes, but certainly, you know, a short period of time.
Wasn't any, so after the first one, the officer didn't come back in and say that person was underage, ticket, and then next person comes. They both came through before the seller had any opportunity to know that either one, I guess that the first one was underage. Is that right?
So based on that factual understanding, it's critical to apply recidivist principles under the civil.
Apply those principles, don't we have to just look at what the statute says? And the magic word that it uses repeatedly is violation, person who violates. So what's wrong with interpreting violation as the act of violating the law? And there were 2 violations. They might have been seconds apart, but they were 2.
I'd like to point this court to Pachette versus State, 374 Northwest 2nd, 397, Iowa, 1985. It involves a very similar statute where you had a first violation, second violation, and then the punishment was an increasing, or I guess decreasing the amount of good time credit that a prisoner would receive. Now, just based on the fact that it had first violation, second violation, the court decided we're still going to apply recidivist principles even though it's the acts or the violations occurred within seconds of each other. So simply because the fact that it says date of violation or first violation, whatever that may be, that doesn't necessarily say we cannot apply recidivist principles.
What is that intervening time period that has to be there? It says, it says date in 50 sub 3, the date of any violation. What's the time? 1 day to the next? Is there a matter of hours? What is that sort of magic period?
If we apply true recidivist principles, it would be from the date of the imposition of the penalty. Now, we don't think that that specific subsection, what constitutes the date of the violation, necessarily says what a violation is. It just simply says if you have 2 legitimate violations, this is how you calculate the time period for enforcing this statute. So under recidivist principles, certainly you'd have to have a conviction and then the penalty being imposed first before you can, yes.
Earlier in the statute, at the beginning part of sub 3, it says in any retail, if the licensee or employee is convicted or found in violation? What is the relevance of conviction or found, and when can they be found in violation, if not a conviction?
I believe that based on case law that I've seen, the agency can bring its own action and determine that a licensee is found in violation.
How does that weigh in your recidivist discussion?
Is in favor of a recidivist discussion because it requires notice of wrongdoing first. You have to have the conviction, you have to have the finding first, and before you can affirmatively say this is a violation.
Legislature, going back to Justice Mansfield's point, the legislature is saying the date of any violation shall be used in determining the period between violations. It's not the conviction, it's not the finding, it's the violation. The violation happens when you sell to a minor. So, and if those are the same date, there's no difference between them, they're within 2 years of one another, it's hard for me to escape that just looking at the plain text of the statute.
And that, Your Honor, I still kind of want to stick with the recidivist principles, then I'll kind of get to this date analysis that's...
Conceding I'm right, or...
No, Your Honor, not conceding you're right, not yet. Certainly, we believe that I think I tried to explain it to Justice McDermott. Simply it's just saying the date of the violation requires some period of time. That doesn't say when a violation is supposed to be imposed, just like with recidivist principles. Again, I encourage this court to look at Pachette versus State, that even though you have first violation, second violation, that decreases the amount of good credit time for inmates, they still don't consider that to be, the date of that violation.
Reject kind of this recidivist principle or purpose interpretation in the Gardner case last year, where it was kind of a similar argument in a criminal case where you're getting enhanced penalties for second offenses, but the crimes are committed before any of the convictions are entered. And we said you have to follow the plain language of the statute. And while certainly it has some recidivist purpose behind it, we just can't ignore the text.
Understand that, Your Honor. Again, I'm not too familiar with the Gardner case. I am familiar with the idea of how this would, or kind of this argument that recidivist principles don't apply to kind of these civil settings. Certainly, Pachette involving prison disciplinary violations, those are technically civil in nature, and I think that's close enough to a civil proceeding. And then second, I'd point this case to Walsh versus Kirby, the California Supreme Court decision. Now, the ABD doesn't want to discuss this case at all, but it's very similar to this case. It involves a liberal construction clause similar to what is included in our Chapter 123. It involves an escalating civil penalty scheme for violations of illegal liquor price cutting. It includes a mandatory shall provision within that statute that says the agency, whatever the California agency is, has to enforce the statute. It also has a provision that says the date of the violation shall be considered when, or each sale shall be considered a violation when construing that statute. But the California Supreme Court applied these recidivist principles despite the fact it's in a civil setting. They noted that the tactics used by the California ABD constituted excessive and arbitrary enforcement of that statute. Certainly, a licensee wouldn't be able to figure out what consequences they would have or be able to fix them. It encourages criminal activity because it's other people see, hey, there are individuals who are not getting charged for this, but then eventually later on get charged for that.
This question about the whole policy argument that you're making. And I understand there could be more learning if there was a time period in between and all that sort of thing. But it does seem to me that there is a difference between a store making one illegal sale and two illegal sales. I mean, right, there could be a rational basis for saying, if you make one illegal sale, that could be a fluke, right? But if you have two, and particularly like tonight, on the night here, it's just one right after another, that sounds like a broken system. And it does seem like a reasonable basis for having an escalation of the consequences.
I understand where you're coming from, Justice May, but there's a reason why the penalties are significantly different from when you have those two different violations in escalating them. I would also point this court, and yourself, Justice May, to the affirmative defense located in subsection 4 that 2.50A statute. Obviously, the purpose of that affirmative defense is for individuals to take the IPACT learning program. If they garner a certification from IPACT, they get affirmative defense that says this violation doesn't count. Certainly, that affirmative defense seems to suggest that it's based on recidivist principles where otherwise the state could simply just charge 4 or 5 at a time and not have to deal and just garner all the way up to revocation or suspension. And there's other portions of the statute that indicate, just like this affirmative defense, that the statute is recidivist in nature. For example, a local authority, if they find a violation of 2H, they can only impose a first violation. That's subsection 30 in subsection 39 of that statute. And on top of that, the legislative textual development of the statute seems to indicate that the legislature wanted to have a recidivist approach. Originally, this kind of license suspension or revocation started in the Iowa Code of 1966. First violation required suspension automatically. But then by 1971, the Iowa legislature changed that approach in order to be more to a graduated civil penalty system. And then in '89, I want to say, that's when they introduced the civil penalty for the first violation. So it seems to me that the legislature intended to have this gradual result that embraces somewhat of this recidivist mindset where it's targeting persistent or repeated conduct. And that's the critical test for whether a statute is recidivist or not. And based on all those factors there, we believe that this statute is recidivist in nature and would require an imposition of the penalty first. But even so, we have problems with how the language is structured, the plain language, with regarding the date of conviction, as you noted, Justice May. It just doesn't seem to make sense if there's 2 violations happening on the same date, which I think the state agrees is an indivisible component of time, a whole 24 hours. And then when it says that shall be determined for the period meaning a length of time has to actually exist or passed, violations happening on the same date literally have no period between each other. I mean, that seems to be kind of embracing a recidivist mindset.
Point of that provision, just to say if you go 2 years without another violation, we're going to start over. You've got a clean slate now. It's sort of like OWIs. After 6 years, another charge. It's an OWI first, not a second. So isn't that all that provision is doing?
Subsection 3E1 on the date of the violation.
With a 2-year period.
I think I understand where you're coming from, Justice Waterman. Certainly, the legislature could have chosen a different metric for how to calculate what constitutes the intervening time for such a violation. For example, time. I mean, the Iowa legislature is well aware of our EDMS rules that knows how to calculate a specific sanction based on the time, such as 9:45 and 9:50 or whatever single seconds in between. And certainly even in this statute under Iowa Code Section 123-107-1B in charging for informations and indictments, those tools don't require the use of the exact time for when a manufacturer or an illegal sale happens.
So if it were the first purchase were at 11:58 p.m. and the second were at 12:02 a.m., then you think there's no issue because they're different dates.
Based on recidivist principles, we would certainly have a problem with that. And that's somewhat of an absurd result that this court should avoid by embracing a recidivist principle mindset. Now, if it's like a separate date based on our plain language interpretation, yes, I do see your point, Justice McDonald, that there is 2 separate violations. However, I do think there are other mechanisms, ideally, in the agency code that would prevent that from happening, such as claiming that the agency action is arbitrary and capricious. I don't like to use the term, but maybe some form of selective prosecution argument or analysis to hopefully combat such an issue that would arise there.
Results approach in the ADB's position would allow you send 4 minors in back to back within a matter of minutes, then you could revoke the license.
Correct, Justice Waterman. And let's take it to a different level. 4 individuals sit at a restaurant, 3 p.m., want to have an afternoon drink. Each of them gets separately transactions. That would be a violation of the statute, too. So it's not just buying back to back to back. It's sitting in any form of restaurant or establishment that has an appropriate license.
Person buys a six-pack, walks out the convenience store, turns around, comes back and buys another six-pack. That would also be 2 violations under their theory.
Under the recidivist approach, I mean, in terms of
You would say no, but it's still.
ABD's interpretation, yes. Are there any?
And then go back and go to the case and ring that one up.
I'm sorry, I kind of didn't catch the last part of the question. I'm sorry.
Come back anyway. He got dinged for it, yep. Okay,
Other questions, I take it?
I bet. Okay, Mr. Lundquist.
Good morning, Chief Justice Christensen. May it please the court, counsel. My name's John Lundquist. I'm from the Iowa Attorney General's office here representing the Iowa Department of Revenue. And by extension, given government reorganization that occurred during the time period in which this case has been pending, the former ABD and its functions were subsumed by IDR. So that's technically why I'm here on behalf of IDR, even though ABD began this matter. Iowa law provides that a retail alcohol license is not property. It is a personal privilege that is sanctionable for cause. Given the public safety concerns intrinsic in the sale of alcoholic beverages, the Iowa legislature has instructed that all code provisions regulating the sale of alcohol shall be liberally construed to accomplish and promote the protection of the welfare, health, peace, morals, and safety of the people of Iowa. One of those prohibitions that a person who has volunteered to get an Iowa alcoholic beverages license agrees to comply by is that they will not sell, give, or otherwise supply an alcoholic beverage to a person without exercising reasonable care to ascertain whether that person is of legal age. And those licensees, whether it be, as counsel pointed out, a packaged liquor store or a restaurant or bar, whose employees are either convicted or found in violation of having made that illegal underage sale, those licensees are subject to certain specified mandatory penalties spelled out.
Agree with me that if there'd been a little bit of chess playing involved, the same set of facts with this adjustment, I say the kid, who knows how old he was, but the person who did the selling pled guilty immediately to both. And if his employer had said, plead to one immediately, and then we are going to buy some time and wait and play the game of, I'm not going to plead guilty, I'm going to set it for trial, I'm going to waive speedy, all that business. Maybe I can't remember what the penalty is. Is it a simple misdemeanor that the guy was charged with, the seller?
I believe it's a serious
He definitely had time hanging over his head. So he could play that game. And the way I know our court system is, it doesn't take much to persuade someone, I need more time. So let's say they push it down, kick this can down the road and don't plead or don't have a guilty finding for a year.
Under that circumstance, I think, falling back on the language that was cited in 12351E, that we look at the date of violation. When did that sale occur to determine the time period for whether or not the penalties that are mandatory in that provision are imposed. And so in that circumstance, we have a first violation that 12353 would require us to impose that mandatory $500 civil penalty immediately upon that first plea. Then after that time period gets drug out for a year or whatever, if a conviction ultimately is entered in that case, then that would be a second, because that conviction would be for a violation, a sale that took place within that 2-year window. So I think the purpose of that language being put into the code is so that both local authorities and the Alcoholic Beverages Division can consistently apply. How do we measure that 2-year time period or 3-year time period, depending on how many sales we have. And so that we can consistently apply that window, we look at what day did the sale occur.
I guess going to the question that we were asking Mr. Appel, if a buyer comes up with 3 cans of beer and says, I want 3 separate transactions, I want 3 receipts, buys 1, pays, number 2 pays, number 3 pays, 3 violations, that's it?
I think you need to look at principles as to how do you determine what constitutes a unique or separate, distinct violation. In that particular case, if we end up with 3 tickets being issued and 3 tickets being found to be convictions, then I think the mandatory nature of 12350 kind of ties the agency's hands, because the way 12350 is written, the plain language of that is upon implementation of the triggering event, and this court years ago in the Randall's International case determined that the triggering event is the actual fact that the employee was convicted, not whether or not a sale occurred, but the fact that they were convicted. Therefore, we have to impose those mandatory penalties. And so if we have 3 convictions,
That's it. I mean, as I read 12349, whatever it's 2H, it says sell, give, or otherwise supply any alcoholic beverage to any person, knowing or failing to exercise reasonable care to ascertain whether the person is under legal age. So with the 3 cans of beer, if he's convicted of 3 sales, that's it.
that's the plain language that the legislature chose to use. They're the policymakers. They're the ones who have determined that the sale of alcohol is so imbued with this public safety requirement that people need to follow the rules and follow them strictly. Now, I understand that as I admitted earlier, has that feeling of unfairness to it. But liquor licensees know these rules when they get the license, and therefore,
Looking at the language of the statute, what do we do with the fact that they talk about a first violation and a second violation that leads to sequential type language? They could have easily said, if you've had 2 priors, like something more like the Thomas case, if you've had 2 prior convictions, then you get this heightened enhanced penalty. But instead, they use this sequential language. What do you do with that language?
I think in Thomas, they define what an habitual offender is simply by the number of violations that occurred. And I think here, the same is true, that the
First, they say second, they say third, a first violation, a second violation, a third violation. So they're not, and they talk about, in E, it talks about determining the period between violations. So doesn't that suggest sequence and not just number?
there may very well be a sequence requirement to that, but the question is how do you measure what the violation is? What's the trigger for those sequential penalties?
Or a finding, isn't
That's,
conviction or finding, and then there has to be that notice. Doesn't that bring in the recidivist notions from our prior cases, Conley in those cases?
I don't believe so, because, ultimately you look at the language that was used here, you look at habitual offender statutes, and they actually use the word, prior conviction. Here we talk about upon a first violation, upon a second violation, and so it doesn't require that there actually be completion of that prior finding before the next one becomes sanctionable, because we're interested in ensuring that liquor licensees don't engage in, excessive misconduct that leads to multiple sales to underage people. That's the harm that we're trying to prevent here, much as in Thomas, we're trying to prevent, unsafe drivers from, driving down the street. And so if you're going to engage in a course of behavior and action that results in multiple sales taking place, then it's only appropriate that we enhance those penalties for each successive finding in that circumstance.
Agency have any discretion in terms of imposing these sanctions or making findings of violations?
I would state that, given the case law, that if a conviction is a trigger, the conviction, obtaining a conviction is outside the authority and ability of the Alcoholic Beverages Division, or the IDR, to control. We're not peace officers. We don't write tickets. The ABD in that circumstance is relying upon local law enforcement.
Weren't there both, wasn't there an ADB representative and Dubuque police officers on the scene?
You're correct, Justice Mansfield, that there was an ABD investigator present who was assisting the Dubuque Police Department in the conduct of their age compliance check, but that ABD investigator can only provide assistance. He can't write tickets. He doesn't tell the PD how many violations occurred. His job was to go into the store and help, observe.
Know that for a fact? Maybe this investigator did say write 2 tickets. Maybe the police said, what should we do? And the investigator said, well, that's 2 separate sales, 2 tickets.
It's still the police department ultimately that makes that call to write the ticket, and it's the county attorney who ultimately is responsible for ensuring that how that case is going to be prosecuted.
That reflects how frequently ADB or ABD, so anyway, however, is there any evidence in the record about how frequently this kind of violation occurs where you have multiple violations on the same day? And the reason I'm asking is, I think you can sense from the questions, it seems like the statute has some sort of educational or recidivist purpose in these escalating penalties, and it does seem somewhat unfair to kind of blow through them. I mean, in this case, it's 2. There's no reason it couldn't have been 4 or 10, where you have a person who has a license, who owns a store, who has an employee, who maybe despite their best efforts at training violates the statute, and now they're out of business. That seems a little bit unfair.
And I would concur with the appearance of unfairness under that circumstance. As I indicated earlier, that's a policy choice that our legislature has made, given the fact that, this case hasn't been before the court before. I think it's safe to say that that type of scenario does not happen very often, that multiple tickets are written as a consequence of multiple age compliance checks. But at the same time, if an officer were to walk into a bar and there's 6 tables and there's 6 16-year-olds sitting at 6 different tables who each were served, that would constitute separate violations that I think rightfully, and as the legislature would have requested, that those types of cases be prosecuted and the full sanctions be imposed. Keep in mind, as I started off my comments here today, that a liquor license is a privilege. It's revocable for cause. And so people who agree to sell alcoholic beverages by obtaining one of these licenses know that they're in a heavily regulated area, and they do have a responsibility to both hire good people, supervise them, train them, provide them tools, whether it be ID scanners or calendars or what have you. And yes, mistakes occasionally do happen, and there is an opportunity in the code for an affirmative defense that, had the person in this case been trained under the IPACT, would have reduced and eliminated that 30-day suspension and $1,500 penalty that they're here appealing. And so we're not eliminating the ability of licensees to engage in this affirmative defense.
The sort of textual argument, 12350 sub 3 sub e sub 1 states the date of any violation shall be used in determining the period between violations. Black's Law Dictionary defines date as the day when an event happened or will happen. What do you make of that argument, that actually we should be looking at day, or date meaning day, and not specific times within one day.
I think that looking at the purpose of that statute, as I indicated earlier, is to define that 2-year or 3-year window. And so whether you have 2 on the same date or whether you have 2 on different days, they're still within that window because we're looking at when did the sale occur. And so that is how we define the period for imposing those additional penalties. I don't think it requires that sales occur on different calendar days. You know, you end up with, as was alluded to earlier, perhaps an absurd result that someone makes a sale at 1:05 a.m., the bar closes, they clean up, they come back, and at 11 o'clock the next night we have another sale. That's one day. That can't possibly be what the legislature had intended.
We followed the California Supreme Court case in Walsh. What would be the practical consequences for the Iowa enforcement regime?
Practical consequences are there that, to begin with, the nature of the violation that was at issue in the Walsh case dealt with this. I see my time's up. May I continue? Was that a store was selling in excess of the minimum markup or the minimum pricing. And the California Supreme Court found in that instance that enforcing the statute to allow for multiple violations actually impeded the purpose of the statute because it would encourage competitors to match their prices as they were purposely running up cases. I think here we simply need to apply the plain language of the statute as written and find that we have, in fact, got multiple convictions. The triggers, therefore, the mandatory penalties are required. Otherwise, we incentivize people to do kind of the situation that Chief Justice Christensen indicated, is people just simply run that clock out, and until we get that next conviction, we have, I guess, an array of multiple firsts, much as you would in the OWI context, except that's a criminal statute. That's not civil enforcement. So I would ask that our decision be affirmed. Thank you.
Mr. Appel.
Thank you, Chief Justice Christensen. I want to start with Justice McDonald's questioning about how common is this tactic that the ABD and police department use. I'd point you to the testimony in the ALJ, or the administrative law proceedings from, I believe, Thurston Shell. She kind of describes this in my mind, or from my reading, as a common tactic that she sees quite frequently. She describes that she describes that she has an empathetic heart because of the multiple times this happens at the police department level and at the agency level. So I think this is, frankly, a quite common tactic that is being used across the state, but just simply hasn't made its way up onto appeal. And that underscores the significant consequences that we're here to discuss today. I want to jump to Justice Oxley's point with regard to how the statute is structured and with regards to recidivist principles. Again, I'd encourage this court to look at the Pachette case, the case that I cited during oral argument. I think that's very textually close to what has occurred in this case. But the legislature knows how to kind of create a statute that's much more clear on when a violation is considered separate and distinct. For example, there's discussion in the State versus Freeman case with regards to our OWI cases. I believe there was an amendment to the statute in the late 90s, and in that amendment, it stated each violation shall be considered a separate previous offense. Now, that language doesn't really exist here in this case. There's no clear indication from the legislature that we are determining these violations to be separate and apart from each other. While I understand some of the points about the date of conviction, kind of setting the tone for what constitutes a violation, again, we would believe that that simply just creates the calculation for the time frame for the violations to be imposed. not whether they actually constitute an appropriate violation to be considered in that specific time frame.
Of section 123.1. So if we think maybe this is an ambiguous statute and the legislature has instructed us that we should resolve that ambiguity in favor of health, safety, promoting the welfare of the public, that seems like that would counsel in favor of the agency's interpretation versus kind of a pro-business, pro-alcohol sale.
I hear where you're coming from. We've said in more recent cases, such as Roe, that liberal construction really doesn't put one side of interpretation over the other in terms of interpreting a statute. And I'm not so sure liberal construction really applies in this context. The Iowa legislature has decided to have a certain form of escalating civil penalty that it believes is the best method to promote the health, safety, and safety of the public. But adopting the ABD's interpretation is going to lead to a situation where that gradually escalating civil penalty system is rendered effectively a nullity. Justice Waterman and I, we discussed some of those examples, and I believe Justice Mansfield and I also discussed some of those examples. And if liberal construction is the true be-all, end-all, then cases such as Walsh versus Kirby go much differently. Cases such as Walnut Brewery, for example, they also go much more differently. And I am also concerned, do you have a question, Justice May? Sorry.
I do have a question. I was curious about how organizations like going to Target, going to Hy-Vee, going to a lot of other places that aren't having consecutive sales to minors and having the same problem that your client had. How does that happen if this is such a widespread enforcement project? And I guess the answer that your opponent suggested is that there are a lot of techniques that alcohol sellers can use just to make sure that this isn't happening. Is that fair?
You've kind of referenced how there's a bunch of big box stores, for example, that haven't had this issue come up before.
Too.
I mean, I think it's just the fact that it hasn't been appealed and made its way up, so I don't take too much emphasis on that. But what concerns me the most is that, there's a vicarious liability aspect to putting a penalty on a licensee. It doesn't matter what their intent is. It doesn't matter how well they did anything or to try to prevent something. As long as a mistake happens, they are still subject to that penalty. And I think Randall still stands for the proposition that there is some form of a due process interest to ensure that if you have these escalating civil penalties, they should be used appropriately. Are there any other further questions for me before I wrap up?
May we wrap up?
Christensen. Your Honors, I believe it's time to end this common tactic that is being used, according to the ABD, that's just simply fundamentally unfair to licensees, is inconsistent with the recidivist principles that are established in 123, subsection 50, sub 3, inconsistent with the plain text, and certainly leads to collateral consequences that should not be accepted. For those reasons and others discussed here today, we ask that this court reverse and remand for entry of dismissal of the second violation. Thank you.
The case of Beecher versus Iowa Department of Revenue Alcoholic Beverages Division is hereby submitted.